Good afternoon and welcome to Coast Legal Aid's Legal Learning. My name is Geraldine DiBianchi. I'm the Mobile Justice Squad in the Senior Citizen Law Project. Along with my two colleagues, Denisa Holmes and Jessica Alexander, we will be presenting a brief overview of advance directives. In particular, there are three forms we will be focusing on: the durable power of attorney, the healthcare surrogate, and the living will. Just for your edification, all the information included in this slide is current as of March 11th, 2025. What is a durable power of attorney and what power does it impart upon an agent? A durable power of attorney gives the agent, which means the person appointed by the principal, the authority to handle all financial and business matters that the principal would be able to do so his or herself, which includes banking, bill paying, stocks, bonds, and any and all other financial matters. This document takes effect immediately upon signing. This bypasses the need for a guardianship in most cases, and most importantly, this document and the power within it should only be given to someone you implicitly trust. It is governed by Florida Statute 709. Next slide. The definition or meaning of durable in the durable power of attorney means that it remains in effect even if the principal becomes incapacitated. And it's also important to note that this document dies along with the principal. It is no longer effective upon the death of the principal. Next slide. Next, we will be discussing the designation of healthcare surrogate, and I will turn it over to Denisa.
So what's a healthcare surrogate? It's a person that you choose to receive your health information and to make healthcare decisions for you if you're unable to do so. And the key word here is unable. So when you are no longer able to speak on your behalf, this person will step up and make sure that your wishes are carried out. So they're pretty much a co-pilot. They're going to make sure that your wishes are followed. When does it take effect? It takes effect either immediately or when you are no longer able to make your own healthcare decisions. So but keep in mind, you want to go ahead and do this in advance, but at the time of signing, you get to decide whether or not you want it to go into effect either immediately or later on. Next slide. Powers of a healthcare surrogate. So you get to decide what they can do. You're not signing away all of your power. Your decision will always trump their decisions, but you get to decide how involved they are. You get to decide if they receive all of your healthcare information, whether that's past, present, or future, or maybe it's just some of your information. You get to decide. You can decide if they can make consent to healthcare treatment or refusal to healthcare treatment. You can also decide how much information they have access to, so they can apply for benefits for you, like food stamps. And you also get to decide whether or not they have the power to make anatomical gifts, which is pretty much organ donation.
Okay, living will. Living wills are governed under Florida Statute 765.03, and it's a one-page legal document, but it covers some very important issues. In a living will, this document authorizes the appointed person to carry out the principal's wishes, not to have life-prolonging procedures if the principal has an end-stage disease, terminal illness, or is in a persistent vegetative state. Next slide. The principal can appoint the healthcare surrogate to carry out these wishes, but per the statute does not have to. So the principal's failure to designate a surrogate doesn't invalidate the living will. This document, the living will, is often confused with a last will and testament. So we just want to make it clear that these are not the same. A living will and a last will and testament are two different legal documents. Next slide. A question that often comes up is about pain relief. If I refuse life-prolonging care, am I going to be in pain? The answer is no. The statute actually states that the principal should be permitted to die naturally with only the administration of medication or the performance of any medical procedure deemed necessary to provide me with comfort care or to alleviate pain. So it does allow for pain relief, hydration, but nothing that would prolong the principal's life. Next slide.
So let's go over a few things. Can you change your mind on any of these documents? Yes, as long as you are mentally capacitated and competent, you can change, destroy, make new ones, whether that's done in writing or you could do it verbally. You can express your intent to revoke or amend it at any time while you have capacity. Keep in mind that copies are the same as originals, so the original should remain safe at all times, and copies of your power of attorney and your healthcare surrogate should be placed in the right hands, and copies should and are exactly the same in weight as the original. These, of course, should be kept in a safe place, but not in a safe deposit box, because in order to access a safe deposit box, if you are not the person whose safe deposit box it is, then you'll need a power of attorney to get in there. If that document, the power of attorney, is in the safe deposit box, then a court order would be necessary to get in there. These documents are effective only while the principal is living. Remember that. They are advance directives for when there is a time in your life that you're unable to make these decisions. These are not documents for after you have passed away. Next slide.
Here are some other areas that our office covers at Coast to Coast Legal Aid. We have a family law unit, a senior law unit. We have a public benefits unit, as well as a disaster response team.
Thank you, Denisa. Thank you all for watching. We hope you learned something today. Please reach out to us with any questions. Remember to follow us on Facebook, LinkedIn, Instagram, X. You could go to our webpage at any time, Coast to Coast Legal Aid of South Florida, and apply for our services any time of the day or night. And tune into Legal Learning every Thursday at noon and Fridays with Friends every Friday at noon. Thank you so much.